Hey, very good afternoon and welcome to another session of Lunch and Learn. And as part of our Divorce Awareness Week, today we will be discussing the topic of you have been served with a summons, a divorce summons. Now what? What should be the next steps? We'll also give you some tips on how to prepare for your divorce, the stages of divorce that you will go through, and answering some common questions that you might have. Good afternoon. My name is Eugene Opperman. I am a family law practitioner specializing mostly in maintenance matters, divorce matters, as well as domestic violence matters and all matters pertaining to matrimonial situations. This webinar is proudly sponsored by our firm. If you would like to get in touch with our firm, you can drop us a line at eugene@oppermansinc.co.za, or you could use the Lunch and Learn inbox at info@lunchandlearn.org.za. Before we get into that, our webinar topics for today will include the following. And we will be discussing, as I've said, you have been served with a divorce summons. What should be the next steps? What should you look out for? And how should you prepare for that? Erin will take us through the question of who gets the ring during a divorce period. Usually there is a wedding band or something like that that might come into play. So who gets the ring during this whole divorce process? In furtherance of some questions that we had, I'll be discussing the role of the family advocate in a little bit more detail, give you some practical tips on how to prepare for your divorce, and then also answer some common questions that you might have, and to tell you more about some of the pitfalls that you might encounter during your divorce period. I'll also be addressing the question that I get very often, is that can you date while you are busy with the divorce process, and what would be the legal implications? And then lastly, because we're looking at divorce in more of a holistic approach, we'll be discussing the emotional stages of a divorce proceedings. Just to get some logistics out of the way, if you have registered on our web portal, www.lunchandlearn.org.za, you would have received a link that would bring you to the website where you would get access to the course webinar, or the webinar details, the handout thereof, as well as some additional information that you would find in the resource and templates folder that you could download at your leisure. For those people that have not registered and watching all of our social media platforms, we urge you guys to register in order to gain some more insight with additional documents and the resources that we post on there as well. The registrations are free of charge, and it's presented by our officers. And you can just venture over to www.lunchandlearn.org.za to do your registration. But without further ado, as I've said right in the beginning, we are approaching divorce in a more holistic way, because we realize that with the years of experience that I have in specifically divorce litigation, is that there's basically two main components, and the one is the emotional component, the other one is just the financial component, where financial decisions need to be made. Financial decisions might include obviously the finances, and then as well as the legalities, the formal structure of how you would go about, what documents do you need, and the whole court process, which we dealt with in previous sessions. We will be focusing a little bit more on the emotional aspect of divorce. Also, specifically later on the next webinar, we will be dealing especially with children. How do you tell your children that you are getting a divorce, and child maintenance and so forth? We will be discussing that at great length as well. To start off with, divorce, like I said, is never an easy process. It usually it takes a while. It's not something that happens overnight. It usually comes along quite a long period of time, up until a stage where you decide that you had enough and you want a divorce and you want out, and the marriage then has irretrievably broken down. common pointers that we could give you once you are being served, once you get served with a divorce summons. There are a number of things that you should bear in mind. Remember that the divorce summons might be unexpected. You might not know that your ex-spouse or your soon-to-be ex-spouse is planning a divorce. So it might not be expected unless you guys have talked to each other in order to come to some kind of agreement, or it's been coming a long way. During the whole divorce process, one should be very careful that emotions do not run very high, because it is an emotional period, and you should take the necessary self-care and introspection for yourself in order to guide you through this whole process and to make you stronger, so that you feel empowered after the whole process. So once you have received a summons, my suggestion would be that you carefully read through the summons, calm down to a steady panic, because it might be unexpected. So read through the whole summons and the particulars of claim, and try to understand exactly what it is that your ex-spouse is wanting from you. Very often what happens is that there's a lot of anger as soon as you receive the summons, and that you do not understand the contents thereof. Because it is a legal document, it might be scary, it might be daunting, and I would urge you guys to seek someone to explain the legal terms to you. If there is talk of division of assets, the splitting of pension funds and so forth, it might be advisable to obtain legal advice so that you know exactly what you're in for. Please do not just ignore the summons. If you just simply ignore the summons, it might mean that the opposing party, the respondent, or the plaintiff in this matter, would be able to apply for a default divorce, which basically means that they can go to court because you have not responded to the summons, and that they could get the divorce in your absence because you were served personally with the summons and you have done nothing with regards to litigation or to settlement of the process. So do not avoid the summons at any cost. One practical tip is to avoid any form of confrontation. During this divorce period, this time, it would be a high conflict situation because it might be unexpected. So try and avoid any confrontation. If you are legally represented, or if the other party is legally represented, remember that it is up to the attorneys now to fight on your behalf, or to try and manage this whole divorce process on your behalf. Try and create a support system wherever. During this whole process, you are not alone. You do have friends, family that might be supportive. They might assist you with accommodation or any form of emotional support. Also, be very wary of listening to these type of parties, because they would probably try and engage by the knowledge that they have. They might have been gone through a divorce, and they will tell you their experience. No two divorces are alike. They are all separate. They are all unique. And it is pertaining to your specific situation. So do not listen. You can get the support from people, but try and steer away from the advice that they would give you unless they are qualified legal practitioners. My advice also would be to seek legal assistance as soon as possible. As soon as you have received the summons, to seek the legal representation and advice for understanding of what is said in the summons, but also to know what your rights are for the continuance of the litigation. Next up would be who gets the ring in the divorce, and Erin is going to take us through this whole portion of who gets the ring during a divorce, this whole divorce proceedings period. Over to you, Erin.
Who gets the ring during a divorce? So we will now deal with engagement rings and who is entitled to the engagement ring once the spouses are now divorced. This is a very interesting question, and there are two situations which we need to distinguish between. The first situation is where the parties were married and they are now getting a divorce. And then the second situation is the parties have not yet married, they were only engaged and they have now broken up. The engagement is now over. who gets to keep the ring. In terms of the first situation, where the parties got married and they are now getting a divorce, that engagement ring is seen as a gift. This means that the party to whom the engagement ring was given gets to keep the engagement ring. The other spouse does not have a claim to that ring, as it is considered a gift. However, in terms of the second situation, where the parties were never married, they were merely engaged and they have now broken up, that engagement ring must be returned to the person who has gifted the engagement ring. Therefore, a distinction is drawn between these two situations. Where you have married and are now getting a divorce, you are entitled to keep that engagement ring as it is seen as a gift. However, if you were never married and you were merely engaged and the engagement is now broken off, that person must give back the engagement ring to the person who gifted it, regardless of who ended the engagement, and also in terms of the first situation, regardless of whose fault the divorce is or who instituted the divorce proceedings. Regardless of that, that engagement ring is seen as a gift, and then the person to whom it was gifted gets to keep it. And then regardless of who ended the engagement and regardless of whose fault it was that the relationship is now over, that person must return that engagement ring to the person who gifted it to them. So this is very interesting. I'm sure you have been wondering about that one. Thank you. Back to you, Eugene.
Thank you, Erin, for that. As a result of previous webinars, there was a couple of inquiries regarding what is the role of the family advocate during this whole divorce process. Now, the family advocate assists parties to reach an agreement on disputed issues such as custody, access, visitation, guardianship, and so forth. That is now if the parties cannot agree to that. Now, the family advocate is their task is to evaluate the party's circumstances in light of the best interest of the child. Remember, Section 28 of the Constitution says that we have to act in the best interest of the children. And then they make a recommendation to the court with regards to access, visitation, and guardianship, and so forth. So the court will only grant a divorce if the arrangements between the parties are in the best interest of the child. So what happens in an unopposed divorce? Usually with an unopposed divorce, the parties are not going through formal litigation. They've probably reached a settlement agreement. They've agreed on the certain terms regarding the children, the care, the access, the guardianship, and so forth. And then that settlement agreement gets sent off to the office of the family advocate for an endorsement. The court will not grant an order of divorce if the endorsement of the family advocate is not filed at court. That is an unopposed divorce. Now, during a opposed divorce, a contested divorce where the parties are set down for litigation, the parties disagree on most of the instances. They might disagree on the visitation, the care, the contact of the children, and so forth. What would happen then is that the family advocate would get involved and they would interview the parties and they would do a formal assessment through their offices, and they would issue a report based on what is in the best interest of the child. And that gets submitted to court, and the court would then evaluate that report and make a final ruling regarding the care and contact and the visitation and so forth of the children. So let me just get to the previous slide. Just as a couple of general comments on the role of the family advocate. The Office of the Family Advocate cannot become involved in any matter that has already been finalized. So these are all just matters that are pending divorce. They will not get involved after the divorce has been granted. The OFA cannot be subpoenaed as a witness. They cannot give evidence in court on behalf of one party or the other party, even if the recommendation is in favor of that party. The recommendation of the OFA is intended to assist the court in adjudicating the matter and coming to a suitable agreement or suitable judgment that the court might hand down after trial and litigation. The recommendation is therefore not enforceable unless it is incorporated in the court order, because the report of the Office of the Family Advocate serves as a guideline to give information to the court in order to make a certain ruling or a judgment. Just lastly, the OFA is a neutral institution and cannot act as a legal representative for either of the parties in this matter. So they are completely unbiased. They stand completely neutral. Their task is to uphold Section 28 of the Constitution, where it says they have to act in the best interest of the children. So a step-by-step, I'm going to focus a little bit on the opposed divorces, so the role of the family advocate in an opposed divorce. That is now when the parties are set for trial. What would happen normally is that when the OFA receives an application for an interview, and that could be done by either parties, they would interview both parties, trying to establish the personal circumstances and the backgrounds of each and every party. They would also interview the child with the assistance of a family counselor in order to get the voice of the child. The aim is to protect the child from testifying in a potentially amicable court environment, which is unnecessary because children is not it's not geared for court. They should not go to court. The OFA also helps the parties reach an amicable solution or a viable solution that is agreeable for both parties through mediation and by applying their legal expertise. Now, all of the personnel of the Office of the Family Advocates are qualified legal practitioners, and they would be able to guide you with regards to legal principles and to try and resolve this dispute in an amicable manner. If the parties reach an agreement at the offices or during the proceedings when the Office of the Family Advocate is involved, they would start off by drafting a parenting plan if it's necessary and a settlement agreement that could be submitted to court. If the parties cannot agree during this whole interview procedure with the Office of the Family Advocate, the Family Advocate would simply compile a report, and that would be handed in at court for adjudication, and the court would then decide on the outcome thereof. That is, in short, the role of the Family Advocate. Now, there are offices of the Family Advocate throughout the whole of South Africa. There are grossly outnumbered by the amount of work that they have to do. And there are not enough, in my personal opinion, not enough officers of the Family Advocate. The burden of their workload is quite huge. And you might have to wait quite a long time in order to get a interview with the Office of the Family Advocate. Some general tips on preparing for the divorce. Now, there's a couple of things that stands out, and I've identified at least 5 aspects that should serve as tips for you to prepare once you've been served with a summons. The one is to learn about divorce mediation. Divorce mediation nowadays are compulsory. They, in terms of the High Court legislation, Rule 41, as well as the provisions of the Magistrate Court Act. So the courts would simply ask you or request you to first try an alternative form of dispute resolution by way of mediation before they would entertain the matter in formal trial. So learn about divorce mediation, read up on it. Google it. There are quite a number of good resources available online that could give you an indication of what to expect. And we will also be dealing with divorce mediations in the next webinar. Get financially organized. I know that during this period of time, it might be quite chaotic. There might be anger, there might be denial, there might be shock. But get your financials in order, and that means that you have to remember that at one stage this marriage would end, and that you would be on your own. You would stand as a separate economic unit on your own. So get all your financials in order. Think about things like policies, like banking accounts, and so forth, that you need to change when the time comes for and the divorce decree has been granted. So get your financials in order. Participate in the divorce negotiations. I've seen so many people that just say, you know what, I just want out. I don't want anything to do further, and they do not want to partake in the divorce proceedings. That is totally wrong, and my advice would be is not to do that. Get involved in the negotiation process. Have your voice heard. Not just about how you feel, but also to establish what is it that you need, what is it that you want after divorce, because then you would only have one chance and one chance only. You cannot come back to the court after you have been divorced to say, you know what, I actually thought about this and I want this change and I want that change. That would only happen in very exceptional circumstances, and there needs to be good reason for that. So participate in divorce negotiations. Have your voice heard. If you want to stay in the marital home, voice that to your attorney or your legal practitioner. Voice that during mediation as well. Address your concerns with regards to children and so forth. But become active in the divorce negotiations. The next one would be is get emotional support. Some friends and family, they might offer you advice, which they've probably Googled, and they would compare their divorce, what they've gone through, with what you are going through now, and they would try and give you advice. Steer away from that type of advice. Rather opt for just having people there holding the space for you in order to support you through this whole process. Lastly would be is focus on the big picture. No court will force people to stay together. So divorce might be inevitable. I've had a couple of clients that actually came closer to each other during a divorce process, and then they went for counseling and they stayed together. But in most instances, I would say at about 99% of cases, focus on the big picture, that divorce is inevitable. It will happen. So focus on the big picture, having your support system ready. It's the people that can support you. Have your financials ready. Be prepared to negotiate hard for what exactly you want out of this whole divorce proceedings. So focus on the big picture at the end of the day. The next session that we will deal with is common questions that usually arise during consultation. And those three are: how long will it take? How expensive are divorce? And will it actually break up my family? And Erin will take us through this portion of the webinar. Over to you, Erin.
There are three common questions that are frequently asked about divorce. These three questions is: how long will my divorce take? How expensive will my divorce be? And will the divorce destroy my family? I will briefly discuss each one of these questions. So, how long will my divorce take? This is entirely dependent on the type of divorce that you are instituting. So you get two types of divorces. You get a contested divorce and you get an uncontested divorce. In terms of a contested divorce, this means that the spouses are in disagreement about various factors in terms regarding their divorce. For example, they might be in disagreement regarding how certain assets should be divided. Well, this would mean that various pleadings are exchanged because your spouse has now instituted the divorce action with the summons, the particulars of claim, and then the other spouse has now served the notice of intention to defend and their counterclaim, and the process goes on. This leads to a formal trial. Therefore, in terms of a contested divorce, the process can take up to a year sometimes because you still need to exchange all the pleadings, you have to go to court, it is an entire process. Whereas in terms of an uncontested divorce, the parties are in agreement of most of the terms of their divorce. They settle outside of court. So they enter into a settlement agreement. If there are children involved, they enter into a parenting plan. The process is much quicker than a contested divorce. And sometimes you can even settle the divorce as soon as an opening opens up on the court roll. So it can take anywhere, depending on the type of divorce, it can take anywhere from up to 10 weeks, up to an entire year, depending on the process. How expensive will my divorce be? This ties in with the first question. So again, depending on the type of divorce, if you have a contested divorce or if you have an uncontested divorce, this will determine how expensive your divorce will be. It is always advisable that if you have a contested divorce, that you appoint a specialized divorce attorney to ensure that you get what you are legally entitled to in terms of the divorce. As such, those fees are not always cheap. So that is an expense that you have to pay if you get a contested divorce. You also have to exchange pleadings. This includes sheriff's costs, and also you have to go to court. Whereas with an uncontested divorce, you merely sign the settlement agreement and the parenting plan. So again, depending on the circumstances, depending on the type of divorce, this will determine how expensive your divorce will be. The last question is, will the divorce destroy my family? This depends on the type of divorce, again, and the type of person that you and your spouse are. A lot of contested divorces might lead to bitterness, resentfulness, and anger. Your spouse is angry because you are now claiming assets which they did not want to give to you. It leads to resentment. Whereas if it's an uncontested divorce and the parties are in agreement, they might feel more happy. They might not be mad at each other. Everyone's agreeing on the terms of the divorce. It is more amicable. However, it is also possible that if there are children involved, that you always have to consider their best interest. And the children might be happy that you are now divorced because you seem happier. It is always important to put your children first. So if that means being in agreement with your spouse or not being resentful, not being angry, that plays a big role, because your children look up to you, and how you're feeling is how they would feel about the situation. And sometimes if you just accept that the relationship is now over, the marriage is over, you accept this, you move on from this, you might just live in harmony with your ex-spouse. And so, it entirely depends on the type of process that was followed and how the spouses themselves, how they handle it, and how their family members handle the situation will depend on whether the divorce will destroy your family. Thank you, Eugene. Back to you.
Thank you for that, Erin. I just want to circle back to the question of cost of litigation. Like you've mentioned, with the two, the contested and uncontested divorce, the one being cheaper than the other. The traditional model that attorneys use, legal practitioners use, are usually billable hours where you get charged for everything. If you phone the attorney finding out what's going on in your file, if they make a call to you, if they send you a WhatsApp, if you send them a mail or they send you a mail, you get charged for that. That is usually the more expensive route to go. Nowadays, most of the attorneys are willing to work on a value-based pricing model, where they would give you a fixed amount to say, we'll charge you 10,000 or 15,000 or whatever the case might be for the whole divorce. That is including the trial period of the divorce as well. And those are usually because most clients, I also found our offices also work on a value-based pricing model instead of the billing per hour as you go. Because we felt that clients do not like the uncertainty of time billing, where the value-based model, where you agree on a fixed amount, is much more flexible, and there's no hidden extras, extra fees, and so forth. With this model, the basic principle of a value-based pricing model is that the focus is on the outcome thereof instead of writing fees as you go along. And that is something that you could negotiate with your attorney when it comes to the first consultation and so forth. A couple of things that you should not do during divorce. The do nots. And there are a couple of those that have crystallized over my couple of years that I've been doing divorces. First of all, do not enter into any arguments with your divorce, with your spouse or your soon-to-be ex-spouse, because that might lead to conflict, and that might actually hamper your process of settlement. Try and steer away from arguing with your spouse. Set clear boundaries. If you have moved out of the house or your spouse have moved out of the house, set clear boundaries of what you expect. Remember now that you have to take charge of your own life from here on forward. And you have to set quite clear boundaries so that the other party could not overstep them, especially when it comes to children as well. Sit around a table, mediate where possible. Get a family mediator involved if you have any discussions regarding the visitation and so forth, so that there are clear boundaries when it comes to the children specifically. Do not overly communicate with your ex-spouse. Do not send them WhatsApps. Do not send them text messages. Try and steer away from overly communicating, because that might also be a drawback when it comes to settlement. Do not let your emotions override your overall feelings. Do not let emotions become so prevalent that it would actually be to your own detriment when it comes to the divorce. Very importantly, is do not sign anything without knowing what your rights are and exactly what you are signing. Do not be bullied by a legal practitioner or by a mediator in forcing you to settle a matter if you do not understand what is it that you are signing and what your specific rights are. One of the other don'ts is do not hide assets, do not overspend, do not try and hide your bank account and so forth, because those things have a tendency to come out during this whole process of divorce. Do not make your divorce into a war. You at one stage, this is exactly what you wanted. The wedding or the marriage was something that you wanted, so there's no need for it not to be amicable, so that you can walk through this whole process with dignity. Do not make your divorce a war. I have a big problem with people living vicariously through their social media platforms. So do not put anything in your feelings and how you have been hurt on social media, because those things have a tendency to bite you during divorce trial litigation, where an opposing attorney might actually use that against you. And don't compare your divorce with other divorces. Like I said, when I referred to your support structure, do not compare that, because every divorce is unique. You cannot compare what you are going through to somebody else, because their situation is completely unique. So do not do that at any cost. The next is a clip that I want to show you from a colleague of mine, Simon Dippenaar, that is practicing in Cape Town as a divorce lawyer. And he deals with some common mistakes that we as legal practitioners frequently find in our legal practice.
Are you thinking about divorce? Hi, I'm Simon Dippenaar and I'm a family lawyer. The decision to divorce is the end result of much soul searching, usually a lot of arguing and a fair amount of indecision. I know many couples who pulled themselves back from the brink of divorce and were able to recommit to their relationship. But sometimes divorce is the best outcome. If this sounds familiar and you're seriously considering divorce, there are some mistakes I see repeatedly as a divorce attorney. Your divorce will go more smoothly if you avoid these common blunders. Mistake number 1, hiring a divorce lawyer before you're sure divorce is what you want. Now, many people make the mistake of using their divorce lawyer as a relationship counselor. If you are considering divorce, work through the process in your head with your partner, if possible, or with a professional relationship counselor. Once you instruct a divorce lawyer, you've entered a legal process, and it will have a way of dragging you along with it, whether you're ready or not. You will have to provide your attorney with documents. There'll be deadlines. If you are using the divorce process as a way of making a decision, you will wind up spending a lot of money, and you may end up getting a divorce you aren't sure you want, because the train has left the station and you're on it, whether you like it or not. Now, mistake number 2, acting behind your spouse's back. Speak with your spouse about the divorce. Don't let them first hear of it when the summons is served. However much your relationship has deteriorated, it is respectful to sit down with your spouse and discuss the future together. Mistake number 3, opting for the wrong divorce process. This is not a fatal mistake and can be undone, but for example, before you jump into a DIY divorce to save money, are you sure you'll be able to deal with complex aspects like pension splitting? Is your divorce as simple as you think? Saving a few £1,000 now could cost you thousands of rand later. Equally, don't assume a court case will give you the best outcome, even if your spouse is wealthy and you want to be sure of getting a good settlement. Contested divorces are always expensive and never pleasant. There are other ways to arrive at a fair and equitable divorce agreement. There are 3 types of divorce in South Africa: uncontested, mediated, and contested. It's important to understand what each involves in terms of time, cost, and emotional impact. Try for an uncontested divorce if it's all possible. And remember, a DIY divorce is just an uncontested divorce without any help from an attorney. It is not a 4th type of divorce. Now, mistake number 4, failing to get your documents in order. Even before appointing a lawyer, gather your financial documents such as bank statements and insurance policies. Put them in a safe place. If they are electronic, set up a secure folder and put everything in one place. But don't confuse keeping your financial information secure with hiding it. Don't hide assets or try to dispose of them. If a judge thinks you tried to deceive your spouse, the consequences could be serious. Just make sure you can access your data when you need it. Mistake number 5, accumulating debt. It may be tempting to lumber your spouse with additional debt, but if you are married in community or property, it's all marital debt. When you divorce, your debts will be split in the same way as your assets. Mistake 6, choosing the wrong divorce lawyer. There are different types of divorce lawyers. Some are sharks, the sort of celebrity you might use to protect or attack significant assets. There's a place for aggressive divorce lawyers, but it's not the way I practice law. For most people, an amicable agreement that respects both parties and allows them to move forward is more important than a combative settlement that leaves the other party emotionally and financially crushed.
Thank you so much for that. And that was absolutely valuable information that we as legal practitioners deal with each and every day in our practice. So the next question that we are dealing with is, can you date during a divorce? Now, will it affect my divorce? The answer is absolutely not. No, it would definitely not. There would be no legal consequences on you, on maintenance. It would not have an effect on maintenance or support of your spouse and so forth. However, from an emotional point of view, it is not recommended that you date during divorce. You might consider your own well-being, your emotional well-being during this period of time. But if you do have that other person that you are dating during that time as a support structure, then that would be fine. There's no penalty of dating while you are busy with a divorce. Next, that I would like to discuss as part of the holistic approach of divorce is the 4 emotional stages of divorce that we find quite often. Now, this was a presentation done by Dr. Corinne Scholes, which is a marriage and family therapist, which I quite enjoyed, where it says that the stages of divorce are similar to that stages when somebody is grieving a death. They are simply general guides. It's not cast in stone. Some people might experience some of them, some might experience all of them, but that is an individual experience by each and every one, and every person is different, and they would experience that different as well. So they are basically 4 stages of emotions that you would go through your divorce. Now, stage 1 is typically the stage where you feel that the whole world has come to an end. It might signify anxiety, depression, rage, anger, numbness, or feeling emotionally drained that you might experience during this first phase once a divorce summons have been served upon you. Sometimes there might also be things like guilt and anger, and the whole process, the emotional struggle of coming to grips that your marriage has ended might be quite daunting, and that might give you a sense of your whole world coming to an end and falling apart. That is the first stage that you might go through. The second stage is experiencing a multitude of emotions. That is usually when it's synced in that, you know what, the process has started, and there might be some unpredicted feelings that you might feel towards the other spouse. And that might also include things like anxiety, rage, emotional blackmail that you want to do, getting back to the other person because you are feeling hurt and not satisfied with this whole process. You might also during this period feel things like loss and loneliness, because the realization might also come to you that you are going through this process, and that at the end of this process, you would be alone, and you might not know how to deal with that. And that is quite prevalent, and it's quite common that these type of emotions surface during this whole process of divorce. Stage 3 is the beginning phase of the identity transformation. This is where you make the psychological, the mind shift, realizing that, you know what, there is nothing that you could do to salvage this marriage, and that it is actually in your best interest that the parties must go their separate ways. Because there's also the saying that they say, you know what, if it did not work in the beginning, or it might have worked in the beginning, but at the end it might not work. So rather go your separate way than staying in a marriage that is not satisfying and it's not psychologically to your own benefit. So that is the beginning of the transformation phase. The last phase, stage 4, that I just want to mention is the discovering of the new you. That is usually when it comes to acceptance, where you know and you realize and you accept that the marriage is over, and that you need to stand on your own 2 feet. And that is the most satisfying and the most euphoric feeling that I found that my clients do have once they come to the realization. Now, in different models, like the doctor said in the intro, was that it is very similar to stages of grief, where you would have the anger, you would have the denial, the depression and the acceptance and so forth. Yes, depression is also a major concern, because most parties, especially the females, go through a period of depressiveness during this whole stage. And I usually tell my clients that, you know what, once you feel that you are in the depressing stage, or the depression stage of your divorce, give yourself a tap on the back, because then you can look back and you can see how far have you come. Because the next stage would be acceptance. And that is usually the final stage of this whole divorce process, where you become the authentic you that you want to be after you've accepted that the marriage is over. That is, in short, the emotional stages that that normal people, or the usual run-of-the-mill people, would go through during a divorce. Like I said, we're doing a more holistic approach when it comes to divorces, and we're dealing with the emotional aspects thereof as well. Now, our firm has a couple of ebooks that is available for free download. You can download all these ebooks that we have written. It's all written by attorneys in very understandable English. There's no legal jargon. It deals with divorce. It also deals with divorcing a narcissist, things that you should know, the addressing of maintenance as well. And then the last book in our range is Divorcing with Dignity, which I urge everyone to read, where you can go through this whole process of divorce, being not acrimonious, but coming out of the divorce with dignity. And these books are all available on our website, where you can download it, www.oppermansinc.co.za, or you could simply scan the barcode or the QR code that is on the screen right now. These books are all available free of charge and for download and for your distribution. That basically brings us to the end of our session for today. We hope that you found it enlightening, that you received some practical tips, not only from myself, from Erin and from Simon, but yes, we trust that it was informative. If you have any questions or would like to come into contact with our officers to assist you with any of the divorces mentioned, or if you have any queries or questions, please feel free to drop us a line. You could either use my personal email address, eugene@oppermansinc.co.za, or you could use the general Lunch and Learn inbox, which is info@lunchandlearn.org.za. Thank you so much for listening. My name is Eugene Opperman. I'm a family law practitioner specializing mostly in maintenance, domestic violence, divorces, as well as matters pertaining to the rights of children. Thank you for listening, and we'll hope to see you soon. Please do read the disclaimer at the end of this presentation. Have a good afternoon further.